Well, welcome to our discussion on regulating crypto assets. Is this mission impossible? Thank you so much for coming or for tuning in if you're watching us on Zoom. We've got an audience here at the library in Quadrant House, and if those of you at the back can't hear me and that bothers you, will you let me know? For those watching at home or from the office, you're very welcome. Just please remember that being on camera adds £5, they say to each of us, and most of us have at least 4 cameras on us, except of course Emily. I'm Robert Temmink, one of the barristers here at Quadrant Chambers, specialising in commercial litigation and arbitration across a broad range of our practice areas. Most of my work's in the Chancery Division, where we're starting to see more and more crypto cases, as some of you will be aware. And we're going to explore a few of the cryptocurrency regulation aspects today. And we'll start with Emily Saunderson, who's going to set out some of the problems arising from cryptocurrencies, though she will not be giving any advice on how to cope with a 30% overnight devaluation in crypto values. I'm sorry, those of you who've been watching your wallets disappear or shrink. Emily's a senior junior who specialises in commercial litigation, particularly in the fields of finance, banking and insolvency. Inevitably, a large part of our work in those fields now involves allegations, and indeed more than allegations, practice of fraud. And Emily has been involved in a broad selection of fraud, bribery and corruption cases arising out of finance transactions. And before coming to the bar, Emily was a financial journalist covering the global derivatives markets. She's a brilliant, tremendous advocate on paper and with her feet. Emily, can you tell us a bit about, with no pressure at all,
money afterwards,
tell us a bit about crypto fraud and maybe just get us in the mood about crypto assets with a few examples.
Okay, so cryptocurrencies, in my view, are rightly synonymous with fraud. And as Rob suggested, I'm going to give you some examples, my top 5 things you should know, episodes you should know about if you're going to get into this area. So the first example is Silk Road. Now, Silk Road was an online marketplace accessible all over the world, and it allowed users to buy illegal drugs online. And Silk Road only accepted Bitcoin. So the way it apparently worked is you went online, you went into this site on the dark web, you could only get to it through the dark web, you ordered your drugs, you paid in Bitcoin, and they magically appeared at your door sometime later. Now, Silk Road was started in 2011, so over 10 years ago. This isn't new, this isn't a new asset class. It was, I say the asset class, I'm not talking about the drugs, that's what we see. And so it started in 2011, and it was so successful that at one stage it accounted for most of the world's Bitcoin transactions. It was closed down by the FBI in October 2013, and its founder was arrested. He's now serving 2 life sentences plus 40 years, in case the 2 life sentences weren't enough, without the possibility of parole, for money laundering, computer hacking, and conspiracy to traffic narcotics. So it wasn't a particularly auspicious start for Bitcoin. The second example is Mt. Gox. Now, Mt. Gox, until it shut down in February 2014, was the biggest cryptocurrency exchange in the world. Cryptocurrency exchanges are important because they're like the off-ramp for cryptocurrencies. They allow you to trade in cryptocurrencies, but they are also the places that you turn your real money, I would say, your fiat currency into cryptocurrency, and you get your legal tender out of your crypto holdings. So anyway, Mt. Gox, biggest crypto exchange in the world, it lost 850,000 Bitcoin after it was hacked, and quite a lot of that was its own funds. At the time, 850,000 Bitcoin was worth around $400 million US. Today, it would be worth over $20 billion US.
Well, yesterday.
Oh, yeah, sorry,
today rather
yesterday it would have been worth
today rather less.
US dollars. And at the height of Bitcoin's value so far, it would have been worth $58 billion US. So this was a massive, massive theft. And the exchange was run out of Japan, and there have been a number of cases going through the Tokyo District Court where the liquidator of the company that ran the exchange has been after various different things from the court. And I don't speak Japanese, but it looks from the translations I've seen like there have been some interesting decisions about the nature of Bitcoin as an asset, and that the judge in Japan has been shown a lot more evidence about what Bitcoin is than the judges over here. Yash is going to talk about the case law, but the judges here treat it as property, pretty much on the say-so of a few lawyers, as far as I can tell. So anyway, that was Mt. Gox. And the third example of the 5 is North Korea. Now, a UN report from 2019 found that North Korea was building Bitcoin reserves because they provide it with, and I quote, more ways to evade sanctions, given that they're harder to trace, can be laundered many times, and are independent from government regulation. So obviously nothing to worry about there. And another UN report shortly after that one found that North Korea had taken over $2 billion worth of crypto assets in hacking episodes against various different exchanges, and it was funding its weapons program using that. So nothing at all to concern ourselves with there. And it's not historic either, because it was estimated last year that North Korean hackers stole around $291 million worth of cryptocurrencies in hacks on 7 different exchanges. In a similar vein, the Venezuelan government apparently was using Bitcoin to try and evade US sanctions before it dropped its currencies pegged to the US dollar and then pegged it to Bitcoin. So there we go. It's the choice of completely legitimate regimes all over the world. And the final example is Quadriga CX, which was a Canadian cryptocurrency exchange. And the owner of that exchange kept all the private keys for the exchange's holdings of cryptocurrency on his personal password-protected laptop computer. So with crypto assets, you have a public key and a private key. The public key allows you to see what's going on in the blockchain. The private key is the crucial thing you need to allow you to actually get access to trade your Bitcoin or whatever cryptocurrency you're using. He kept all the keys on his password-protected laptop. He died very suddenly in mysterious circumstances in India, taking the password for his laptop with him. So no one could get access to the exchange's crypto holdings, and the exchange had to go into an insolvency. It owed the equivalent of 250 million Canadian dollars to its users, who were rightly quite upset about this. And some of them engaged lawyers to try and get an order to get his body exhumed to just check he was dead. Now, as far as I'm aware, that hasn't happened so far. But there have been further investigations, and it looks like it was some sort of Ponzi scheme, so the assets had gone anyway, although there are rumors floating around, and I think there's a Netflix documentary on this, rumors floating around that he's living somewhere on the ill-gotten gains from this exchange and various other dodgy things he was involved with.
With Elvis and Princess Diana.
And Shergar.
And Shergar, yes.
Yes, there are solid grounds for thinking that this is a particularly risky asset class, and it obviously attracts fraudsters.
So is this the wild west of asset classes, or perhaps is it the wild far east of asset classes on the light of what you've described? The problem presumably is that there's no, since it's a global phenomenon, there's no central base.
And in some ways, having central regulation is completely contrary to what a cryptocurrency is. It's supposed to be available to everybody in this distributed ledger. There's nobody who knows who owns what crypto assets. There's no central oversight. That's one of the attractions. It's supposed to be more democratic. So that gives rise to the question of whether you can actually ever effectively regulate it, because you try and regulate it over here and all the business moves over here. But it obviously leaves the courts and the regulators with difficult questions.
Well, let's have a look at that. Yash, should we have a look at the practicalities about getting hold of some of these assets? Yash Kulkarni is one of the QCs here at Quadrant Chambers. He's extremely well known in commercial litigation, arbitration, commodities and shipping. He's got particular expertise in IT cases and telecoms. The legal directories, which we know to be the paragon of virtue and reliability, describe Yash as a formidable opponent, as an iron fist in a velvet glove. But they also describe the Yash that I hope we'll hear from tonight, a canny advocate who knows how to read a room. He's everything an advocate should be: clear, concise, charming, and clever. So Yash, how's the case law developing on crypto? How have the courts actually dealt with these intangible tokens of value?
So the courts have dealt with these intangible tokens of value, and broadly 2 key issues have arisen that the courts have dealt with. The first is how do you classify this asset class? Is it a form of property? What kind of property? Can you hold it on trust? And that in turn feeds into what types of order are available by way of relief. So that's the first type. And the second key issue is jurisdiction. And that ties into who's the fraudster, and therefore, and also how's the cause of action framed. So I'm just going to look at each of those two key issues and sort of give you some of the law that's been developing on that. So the first of those, so the nature of crypto assets and therefore kinds of orders that we can get. So it's now clear under English law that cryptocurrencies are property. Emily gave that away in her bit.
Sorry.
Now, and as of March this year, NFTs are property too. Now, there's now a long line of cases that support the idea that cryptocurrencies are property. And people may think now, well, it's obvious, isn't it? Obviously property. There's nothing obvious about it, actually. And the reason there's nothing obvious about it, and it wasn't previously obviously thought to be the case, is because English law generally operates with two types of property class. So you have choses in possession, tangible things that you can hold, you can possess, and choses in action, enforceable rights. That's it. That's how property works in England. And cryptocurrency doesn't really fit in either of those. So previously, when the courts have looked at in the world before crypto assets, when the courts were looking at things like carbon credits and information in databases, they had a lot of trouble trying to classify that as property. So there's nothing obvious about cryptocurrencies ending up as property. But now the accepted position is they are, and as far as we can see, the accepted position is they could be held on trust. Now all of that's relevant when you're going for certain kinds of remedies, proprietary injunctions, seeking tracing, following, all of that sort of thing. That all stems from the ability to hold these assets on trust. Now, the starting point for when all this started changing is Mr. Justice Bryan's decision in a case called AA against persons unknown. Now, this was back in 2019. Now, in that case, Canadian insurers' computer systems were hacked and some malware was installed, and that locked the insurer out of their systems. A demand for $1.2 million in Bitcoin was put forward, and it was said in return for that, you'll get the decryption software. So the victim contacted their English insurer. The English insurer engaged in negotiations, negotiated the ransom down to just under $1 million, paid it in Bitcoin, got the decryption software, so ransom paid, systems restored. Then they engaged a specialist blockchain investigator to try to find where that Bitcoin went. And they tracked the payment to an address linked to an exchange in the BVI called Bitfinex. And then they bring proceedings. Now, Mr. Justice Bryan found it. This is an interim application ex parte. Mr. Justice Bryan concluded that Bitcoin was a form of property capable of being subject to a proprietary injunction. So really two propositions there, property and capable of being held on trust. And to arrive at that, he relied on the UK Joint Task Force legal statement on cryptocurrency. So they produced a statement, he read it, said, well, that supports this conclusion. And he also said, well, it's also supported by the fact that he thought cryptocurrencies met the indicia set out by Lord Wilberforce in National Provincial Bank in Ainsworth. So that's to be property, it's got to be definable, it's got to be identifiable by third parties, and it's got to have some degree of permanence. He said, well, cryptocurrency's got that, so property it is. And so he granted an interim proprietary injunction over Bitcoin. Now that analysis, the analysis of Mr. Justice Bryan, has been followed in a ton of cases. I can give you names, but they're just going to bore you, but I'll tell you about them briefly. Now, it's important, these remedies, nearly all of these cases, have been in the context of interim remedies for fraud. And that's important because they come with a bit of a health warning, because all of these have been, by and large, one-sided applications, where the propositions haven't been tested through inter partes debate. I'm going to come to one case where there has been inter partes debate, and actually the relief that the claimant got initially was set aside. So the point to have in mind is, I think, until these are properly tested with inter partes debate, I wouldn't get too excited about some of these propositions sticking. So the only other case I'll probably go into a little bit of detail is a case called Iron Science and Persons Unknown. You find that all these cases are against the same defendant. It's persons unknown. Now, Iron Science.
So the Queen bringing all those criminal prosecutions. Weird, isn't it?
So Iron Science was a case where there was really a claimant in this company, and the claimant was effectively duped into investing in cryptocurrencies that didn't exist. And the way the fraudsters went about it is they said they were linked to a well-to-do Swiss company that specialized in crypto investments for high net individuals. And they came to him, and initially they came with a a genuine intro to get him interested. And so he invested a little bit of money in Ethereum and Dimecoin, genuine cryptocurrencies, and they generated a £15,000 return. So he thought, this is fine. He was then persuaded to invest in a supposed brilliant new cryptocurrency. This is something called Uvexco and Oilium, and neither of those actually existed. So he put a lot of money into those. He was then told, they've done really well. You've earned $15 million of profit, but you do need to pay our commission in Bitcoin. So he paid the commission in Bitcoin. Actually, all of this money had just been squirreled away somewhere, which he later found out. In total, he transferred about £577,000 worth of Bitcoin. And then he sued the supposed Swiss entity that didn't exist, and he sued the parent companies of the groups that operated the exchanges of the relevant cryptocurrencies. Now, on an ex parte application, Mr. Justice Butcher granted a proprietary injunction and a worldwide freezing order. And he granted a banker's trust disclosure order against the coin exchanges that process the transactions. So that shows that the courts, when they're faced with crypto fraud, are willing to try to do whatever they can to help you. Now, for example, in the Iron Sciences case, the basis on which Mr. Justice Butcher decided you can order a banker's trust disclosure order against these coin exchanges, it's not entirely clear how he got there, because it was pointed out to him at the time that you can't get permission to serve out on a Norwich Pharmacol order in these circumstances. But he effectively said, oh, well, that's authority dealing with Norwich Pharmacols. You're asking for a banker's trust order. So I think you could get those. Frankly, there's no, as far as I can see, there's no logical coherence to why you should be able to get one and not the other served out the jurisdiction.
Sorry.
No, go.
But the way in which I think they're dealing with, or Mr. Justice Butcher put it, was because you can get a proprietary remedy, you can get a banker's trust order to trace what's happened to the assets, which is different from the personal remedy where you're using a Norwich Pharmacol. But I agree, it's a very tenuous distinction that he's drawing to make quite a big, to serve a third-party disclosure order out of the jurisdiction in the face of authority is actually quite a thing.
And I think the gateway is the necessary or proper party gateway that I think he says that opens the door to being able to get this information from his third parties.
But those third parties, of course, ignored everything anyway.
That's unfortunately one of the bits we're going to later about enforceability of all of this. So there's been a whole ton of cases now, and I think the punchline at the end of it is cryptocurrency is property that can be held on trust, and you can get some pretty extensive orders on the basis of that, freezing orders, proprietary injunctions, and what have you. The other.
Yeah, what about where they are? I mean, you just talked about third-party orders against other people.
So jurisdiction is the other key area, and that's of course, I mean, where assets are located is of course important for what law governs this and questions of jurisdiction, and that's the court's jurisdiction as to things like serving out and can either court deal with this. Now, in the Iron Science case that we looked at, Mr. Justice Butcher suggests that the lex situs, and I'll come to that in a moment, the lex situs of cryptocurrency is the place where the person or company who owns it is domiciled. So if it's a person, fine. If it's a company, where the company is incorporated. And to arrive at that conclusion, he relied on the analysis of Professor Andrew Dickinson in his book, Cryptocurrencies and Public and Private Law. So just to put that into context, the lex situs is the law of the jurisdiction in which the subject property is located. So generally speaking, the lex situs of land and chattels is where its physical location. And the lex situs of choses in action is where they're recoverable, where they can be enforced. So in other words, what he said is the law of the place of the cryptocurrency is not where that cryptocurrency is located or held, but where its owner is domiciled, which is it's an interesting take on jurisdiction. That approach has been followed in other cases, case of Fetchai, a few others. And so it does seem that the weight is leaning towards the idea of the proper jurisdiction is the place where the owner is domiciled. As against that, there's been a very recent case earlier this year called Tulip Trading and Bitcoin Association. This was surprisingly, this is a double-sided case. So someone was on both sides here, and in that case, the judge in the Chancery Division, Mr. Justice Fogg, took the view that actually he didn't think domicile was the correct test. So assuming for now that the right thing to look at is the owner of the cryptocurrency, he said, actually, I think residence is better than domicile. Residence, as you know, will be where the central management control of the company takes place. And where you've got this sort of fraud taking place, it would be unsurprising to have companies incorporated in obscure jurisdictions which had no connection with the ultimate fraudsters. Whereas if you're looking for the center of gravity of where things are happening, you might get a bit closer to the action. So residence seemed to make more sense. And so that question of whether you're looking at domicile or residence for a question of jurisdiction is probably still left open. I mean, just before I leave that case, that was an interesting case because that was a case where the claimants claimed that they effectively obtained permission to serve out against some software developers of some Bitcoin networks. They claimed they'd been swindled, and they claimed that these software developers owed them fiduciary duties and or tortious duties to effectively help them out when things went wrong. Now, they obtained permission to serve out against these individuals, and on the contested application, that service out was set aside. And Mr. Justice Fogg said it was set aside on the basis there was no serious issue to be tried on the merits of the claim. So you don't get out the starting blocks on the merits. There's no realistically arguable case that this ephemeral changing group of software developers would owe fiduciary duties to the claimant, or that there's any need to extend the duty of the accepted categories of duty of care and tort to cover the situation. So that might be important in time to come. It does show how on interrogation into parties, what sounds like a good idea when you're one-sided can sometimes not be such a good idea when it's interrogated. Just before the last thing I'd say on jurisdiction is, as I mentioned at the moment, the case law is all focused on when the owner of that cryptocurrency is based, whether it's where they're domiciled or where they have residence. But you do wonder, I mean, is that the right place to look? Because, you know, cryptocurrency isn't the sort of currency that you keep in your wallet. It's not in your back pocket. You hold it in an exchange. That's the only way you can get the effective use out of it. So you wonder whether the proper jurisdiction should be referable to the exchange that it's held at, rather than by reference to an owner that actually query to what extent they're as close to the action as the exchange would be. But that's really a point that's not really been argued or really dealt with. But it does seem strange that the focus is all on the owner rather than on where the actual cryptocurrency itself is held. Well,
I mean, you're right. That's going to come up for review. But also, I think there's going to be another review about whether they are in fact property.
Yeah.
Because there have been some mathematicians in the States arguing that it really isn't property at all and explaining the blockchain, which perhaps you can just talk.
There'll be another lecture, Rob. No, the thing to have in mind is all of this case law, a lot of it might change because there are some quite new initiatives coming out. So, for example, there's three things I identify, but first and the third are probably the most important. First is the Law Commission are producing a report on digital assets. And two big things they're looking at in that are whether digital assets should be possessable. So English law doesn't recognize the possibility of digital assets being possessed because the concept of possession is limited to physical things. The Law Commission's looked at that recently in the case of electronic trade documents, and it's revisited that concept. So it may do it again with cryptocurrencies. And it's also considering, so the Law Commission will also consider whether English law's traditional dual track approach to property, shows in possession, shows in action, whether that's just a little bit outdated and has outlived its usefulness. So whether you should now have a third category so that you're not forcing square pegs through round holes when you're in court and trying to get what is essentially something quite different to fit within concepts that were built for different propositions. The second thing is there's a digital dispute, a new set of rules being produced to enable faster arbitration of these kinds of disputes. I just mentioned that. The third thing that I think may be quite important is that Sir Geoffrey Voss gave a speech late in February this year where he was suggesting that the rules on service out may be changed. And what he was recognizing is that these sorts of disputes, they span lots of different jurisdictions. So I'll read out what he says. I've set up a subcommittee of the Civil Procedure Rules Committee to look at amending or expanding the grounds on which proceedings can be served out of the jurisdiction. This is always a big sticking point. And it is that obstacle that's impeded many sets of proceedings aimed at tracing the proceeds of crypto fraud. Under current case law, third-party disclosure applications cannot easily be served outside the jurisdiction, even if one can serve out orders requiring a third party to disclose documents relating to the account of someone. I hope the developments in the court's rules will make this fine distinction less significant and will make it generally easier to litigate issues that arise in relation to on-chain transactions and the tracing of crypto assets. So I suppose watch this space. The courts have been doing the best they can with what they've got, but it looks, one hopes, that there may be some developments in the law that make our life as lawyers a little bit easier.
Well, that brings us brilliantly onto Nick Van Benschoten. It's almost as if we planned this. But just before I move on to Nick, for those of you at home or at least watching online, if you have any questions, you can put them in the question and answer chat. And once I'm reconnected to Zoom, which has thrown me out, and I've been given the meeting code and password again, I will try and deal with your questions at a convenient moment. So Nick works in the economic crime policy team for UK Finance, the industry body for over 300 banking and finance firms operating in the UK. He delivers the economic crime policy and also advocacy on behalf of members, leading on international engagement, beneficial ownership, and grand corruption.
Not the petty stuff.
Yeah, exactly. And not, serious fraud stuff. It's really grand, isn't it? He's also, his CV is so astonishing that I'm going to cut it down to just a few minutes. He provides the secretariat for the anti-bribery and corruption panel and for the money laundering advisory panel, working groups on crypto and companies house reform, and he supports UK Finance input into the economic crime reform programme. Let me stop there before I embarrass Nick even further. Nick, what is going on in or outside the Inns of Court, and what's the virtual world like in the real world?
So it's really nice to hear there are legal tools to bear. One of the things we do in UK Finance is we try and deal with what our customers throw up for our members, and I'm afraid that people are very interested in crypto. Crypto is something that, despite everything you hear, despite the clash in value, people want it and people are demanding it, both on the retail side and in private wealth management and so on, which creates problems. I think that our position in a nutshell is that we really hope that crypto regulation succeeds, because the alternative is not worth considering. The key point I would start off with is, if you're going to be able to get the fraud resolved, you need to actually be able to get the information and trace it. So most of our work has been about the signal to noise problem. We've seen this outside the crypto sector. We've seen it in most emerging asset classes. People abuse the legitimate financial system to hide a needle in a haystack. And banking systems, payment systems, card systems, they monitor for anomalies. So the best way to get dirty money through is hide it in a flood of legitimate looking money. And the crypto sector now coming into regulation is starting to face the same problems. I would call it old wine in new bottles. That's maybe a bit too tangible for what we're talking about, but we have seen exactly the same problems.
We've got other fraud cases about old wine in new bottles as well. So new wine in old bottles.
High value dealers and so on. You've got the fear of missing out. You've got people being put under pressure, being isolated, all the usual scam techniques. The interesting thing is you're dealing with a sector that, unlike e-money or money service businesses, it's a sector that's not very clearly regulated. There is a regulatory perimeter in the UK. It doesn't quite match up with the activity. It definitely doesn't match up with the risk profile. You've also got international standards, including on anti-money laundering, coming down from on high, the Financial Action Task Force International Group. Those standards are getting more defined, but they've still got the sunrise problem with different people implementing them in different ways in different countries. We've seen the European Parliament saying no more value thresholds of crypto, it's inherently risky. Well, last year, the UK Treasury proposed, let's make a higher value threshold for what are so-called domestic transfers to crypto. They're less risky. So international fragmentations making it complicated. We don't have the same problem on electronic money or other things. The rules, at least, not the implementation. The rules are simple. And this regulatory perimeter issue matters because if you look back at the original business case for crypto design, the pseudonymous Satoshi Nakamoto, whoever that really was, who designed Bitcoin, said, I've come up with something that has no intermediary. And that was going to be the solution. And the regulatory answer is, no, 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 there will be an intermediary. We need a soul to damn and a body to kick. And that's what we're trying to do now. But you've got uneven regulation. You don't have all the activities of those bodies regulated. You definitely don't have these international bodies operating everywhere regulated in the same way. You'll have heard about bodies like Binance. There's also a decreasing grace period from the FCA on people trying to get regulated in the UK. That doesn't mean they can't do business here. They just can't do regulated crypto activity by way of business. And those lawyers amongst you will obviously know there's a way around that, even if you're not being fraudulent. So it's very complicated. So it's a bit of the old wine in new bottles, but it's got a rather nasty tinge to it. It may have got corked. So what are we doing about it? Thank you. It was you with the high value dealers. The way we're looking at it is we are trying to engage with what are the crypto sector doing themselves. I think what they're doing themselves is recognizing they're themselves under threat. There is an arms race underway between privacy enhancing technologies and blockchain analytics. The arms race at the moment seems to be going well with the help of the security agencies and others very interested in North Korea hacking. The Ronin hack, for example, at the moment is now looking like it went the same way. But still, the arms race is still something that's operated on an exception basis, on a day-to-day basis. We are seeing what happened previously to other regulated sectors happening to the regulated crypto sectors. There is a large problem of them being used as the new way out. I would say cashing out, but it's not cashing out of fraud. It's taking the proceeds of fraud beyond the reach of UK law enforcement. And we've got a number of initiatives at the moment, including a mapping and tracing initiative called the Mules Insight Tactical Solution, or MITS, which is essentially run by the payments operator who gets data together from the banks and sees. So we've mapped some money mule back runs. So there are people who have sold the use of their bank accounts, take fraud and pass it on. It was students, then it went to secondary school kids. Don't know if they're going to primary school kids now, but the organized criminal gangs have a ready population of these money mules, which is hard for the banks to deal with their clean skins. What we've done is we've analyzed, well, where are the networks? Once you've found one, you can trace them back. And as we trace those, we apply analytics to it, we see the latest way to herd your mules is out through a crypto exchange because of speed. And because of the fact it's low value payments, it's from clean skin people, it looks normal. So again, the high adoption of this activities, but particularly on a fear of missing out basis, young people want to get involved. That's where we're seeing cashing out go. It will probably change in a few months, but at the moment it's going up very, very, very fast.
And are the exchanges being cooperative when you say that this is what's happening?
Yes, yes, they are, within the limits of the regulatory perimeter.
Right.
So this is one of the interesting bits when we talk to people, even who aren't regulated here, they have very good best-in-class proposals, very good best-in-class solutions. But when you actually look at some of the challenges they're facing the same challenges the banks are, and yet they don't have the same necessary customer protection apparatus we do. There's no, for example, voluntary scheme to reimburse scam victims. So when you talk to them about, would you mind passing the money back to us so we can reimburse the customers, it all gets a bit difficult. Now we understand that there's going to be a bill going through Parliament where the payment service regulator will mandate authorised push payment reimbursement. We have to see how far that goes. At the moment, we don't know how far it will go. I doubt it will go as far as crypto, but we are having the discussions.
And that's, I mean, that'll be jurisdictionally limited.
It will be jurisdictionally limited, but your point about where do you actually get the people by the scruff of the neck is a very interesting question. So right now, I think what we're focusing on is let's build on that cooperation. We probably need to look at legislative tools. I think any uncertainty from law enforcement, they might not be able to apply an asset seizure, given their experience with unexplained wealth orders. I don't think anyone's got time for that. I think what we're hoping is the government will take the opportunity of the new economic crime bill when it comes, the second one. They come in 3, by the way, there should be a 3rd by the end of the year. Hopefully they will put beyond question anything that walks, talks or quacks like crypto should be within reach of law enforcement. And you were talking about the different types of class you have. There's cryptocurrencies, tokens. There's also the whole range of smart contracts and so on. When you talk about kind of carbon credits, but also quotas, your place in a queue, these are all things that have value, so they may come into play as criminal exploitation. So if it's something that criminals are interested in, we should allow law enforcement to get it. It's our basic unlegalistic principle. And the other point on cooperation, just to finish off,
just before we move on to that,
please.
we've had a question which seems relevant to us now, and it may be Nick or Yash, the best place to answer it. It's this: if the recipient of a misappropriated cryptocurrency is resident or located in Saudi Arabia, then a claim against them in knowing receipt of trust property would fail on the basis that the separation of the legal and equitable interests aren't recognized under Saudi law. Is that a good argument for those ultimately looking to receive misappropriated crypto assets just to put themselves in a jurisdiction where the concept of trust isn't recognized? Is that something that you've had to grapple with when you're looking at this regulatory environment? Or?
We deal with slightly different Saudi examples on anti-bribery. No, I mean, what I would say, that sounds like the same sort of problems that get grappled with when you think about how do you work against people displacing risk into an area where you can't get to it. I would say it does sound exactly like the kind of things, tools like unexplained wealth orders were designed for, but this is a different use case. But that's my easy answer is legislation, government. That's not necessarily the best answer right now.
I think that has to be sort of the ultimate route. Otherwise, you are effectively trying to sort of in an ungainly fashion use the existing rules to deal with something that they're not really aimed at dealing with.
Yeah, and I don't think we really want to answer this question in case we come under the AML. That's involved in a fraud scheme. We don't know how to hide your assets, which jurisdictions you ought to go to.
Just one point on that. I mean, the UAE in particular are responding to a lot of international pressure right now, particularly on proliferation and terrorist financing. They are finding new tools and new ways to align. The UK has a long established relationship with many countries in the region, but they have an illicit finance partnership with the UAE, trying to get them off a grey list they've been put on for anti-money laundering failures. But it is a dynamic environment, and some of the things people are manoeuvring around now is how do you get people to see things in a similar cooperative way? You talked about sector to sector. I mean, the G7 have moved very quickly to coordinate on sanctions. Switzerland has moved on sanctions against Russia, which would not have been on my kind of list. But there are questions about what do you need to bring people on board. Proliferation finance might be one of them. But it's, I think, something we're seeing already around things like ransomware, where you get the US and the UK increasingly taking very forward positions. So that may drive it a little bit faster than it would have done otherwise.
Yeah. And then, sorry, finally, you were...
I was talking about something fairly routine. What was it? Oh, yes, cross-border information sharing. So when we do ask them, can we have the money back, please, for our mutual customers, part of the problem is that we have got difficulties sharing information cross-sector. If it's fraud, then that's okay. But if it's not exactly fraud, you've then got a whole range of other issues. You've also got issues around people's concerns over litigation, but also in terms of breach of privacy. And what we're finding at the moment is when you have that conversation, it goes very well until you get to the actual particulars. We actually do some joint investigations, which is why, again, back to government, we're hoping that we will get in the new economic crime bill some sort of provision for information sharing for all types of economic crime. And we think it should be for all regulated sectors at the very least.
Yeah.
And if not, we just keep it under review and move as fast as we can, because it's no good having the banks run right up to the border and say it's going that way and then have to stop as it crosses the border.
Yeah. So, I mean, yeah, should we go back and look at what legal tools we've got at the moment? I mean, we've touched on them a little bit. What are the hurdles we're currently facing? Can you help Nick shape the economic crime bill to give us the means to get our hands on these ethereal objects?
No. No, I mean, in terms of sort of practical steps for recovery, I mean, at the moment you have the sorts of tools I was mentioning earlier, the interim remedies, worldwide freezing orders, proprietary injunctions, all the rest of it. And who you bring it against? Well, you've got to try to find out who the fraudster is, which is difficult. You go through endless numbers of disclosure order, Norwich Pharmacal, you can get it served out, Bankers Trust, etc. orders to find out the ultimate fraudster, or you can fall back on our friend, persons unknown, if you can't actually come up with anyone.
And you can get those experts, there's some PI people who start interrogating blockchain, can't you?
Absolutely. And those, so in terms of practical steps, I think having an expert involved is going to be imperative because you do need a blockchain investigator or something to work out where this money's gone. I mean, that was the case in the two cases I mentioned, the AA in person summit and an Ion Science case. Both of them had experts involved and they performed sort of the dual role. You might have different people doing this, but the two roles are the actual investigation as to where has this gone. And the second role is how do you explain this to a judge who really won't have a clue as to how all this works. So you need somebody who can perform, or two different people who can perform those functions. So having an expert on board is important.
But the expert can only tell you where the assets are. They can't tell you who's got them.
Yeah.
So you are going to need disclosure. And the way you get disclosure is you go against an exchange, because exchanges are supposed to, certainly in this jurisdiction, since January 2020, I think, are supposed to have KYC information about the people who use them. And basically, if you're a fraudster, unless you're buying pizza or Teslas, you are going to want your money out of Bitcoin. So the exchanges are absolutely crucial. Go against the exchange for disclosure, which is why Yash was talking about Norwich Pharmaceutical Bankers Trust and how solid that distinction is. But that's absolutely crucial because most of these exchanges are not in this jurisdiction. So you need to find a solid basis to get the information. And then you hope that the exchange is going to be cooperative because they want to be seen to be a good player.
I suppose there may be some merit in trying to find out where the exchange banks as well. That might just be piling disclosure order on disclosure order. But if you're trying to follow the money, that's sort of natural continuation in your inquiry.
I'm going to tell this story. I had a very worrying conversation with a banker about this, Norwich Pharmaceutical on top of a Norwich Pharmaceutical. And he said, well, we can spend the money on lawyers. Obviously, don't tell your clients this. We can spend the money on lawyers, or we could just open an account with the exchange because they'd tell us who they bank with. And so, lateral thinking might be a way forward here.
I mean, do you need also, you probably need a multi-jurisdictional, we may well need a multi-jurisdictional team.
That's probably the thing that the claimant client is going to sort of have a sinking feeling about. But the problem is you may get an order from the English court, and it's the point that Rob mentioned earlier about enforceability. You will serve it on the exchange and they'll crumple it up and put it in the bin, because why would they respond to that? So for example, you'll have data stored in a number of data centers around the world, and they'll be controlled by different legal entities. And so you may very well have exchanges that just say, I'm not going to respond to this, unless you get orders from each of the jurisdictions to which I may potentially amenable, all of which tell me to do this. I mean, we've seen something on Telegram where they effectively have said that. They've been served with goodness knows how many requests to provide information, and they've not provided any information, because for that reason, they say we have our data stored in multiple data centers around the globe, controlled by different legal entities, spread across different jurisdictions. Unless you get an order from each of those, we're not going to provide you with anything.
Zero information display so far.
I think they have disclosed zero. So that is.
And they also held it up as a badge of pride. Here we are. Privacy is important, and we have, despite being subject to some audits, because our data is held in different centers around the world, we have disclosed 0 bytes of customer data. That's what we said.
So, yes.
Sorry, would it be a strategy applied by, say, Coinbase, which is listed or reputation type of things to consider, or is that applied across the board by Coinbase Finance?
I don't know if we've got enough. I mean, Nick, maybe you know the answer.
I'd be astonished if they didn't respond to law enforcement requests. That's not the same thing.
No.
But it would be the sort of thing they might. Okay, let me put it this way: we meet with many of those bodies in forums with the National Crime Agency to talk about what we're going to do. That's really important to them. I can't see that would continue for long if they ignored UK court requests. That's reputational. What you're saying is, would they make the reputational call?
Well, as I just said, with this Telegram example, they were holding it up as a badge of pride. No one's got any data out of us.
But admittedly, it's slightly different because it's not an exchange. But it's the same sort of broad principle.
We haven't spoken about distributed finance, there's the whole issue about deliberately not having any soul to damn or body to kick, and that's seen by most regulators as an automatic ruling out of court, because they need to get somebody for the regulatory purposes of that. But you can start to see other things developing now that seem designed to create difficulties like multi-key authentication. Who actually made this decision? You talk about the founder of Silk Road, who went under the pseudonym the Dread Pirate Roberts, which I hope you've all watched the movie The Princess Bride. So you know the references, right? The idea that there was a original founder who then passed on secretly because it was under pseudonym. Nobody knows who it really was. Courts didn't believe that. His leniency claims are still saying I wasn't the only one. But that is actually a realistic governance model of you don't know actually who's behind it. But at the moment, the regulators have closed the door on that. But that is a business model, and it is being marketed as such, as a way to defeat court inquiries.
Well, I think that's probably enough from our panel. I don't know, Nick, whether we've given you any food for thought tonight. If we haven't, I'm sure that we'll have some questions, which might well.
No, it does. I mean, what I would say is that the interesting thing to come is how is the government going to pay for all of its economic crime ambitions? And so far, the answer seems to be an economic crime levy on the regulated sector for 100 million a year. There are lots of very interesting parliamentary suggestions that the government might want to match fund that. You never know. But there's also a lot of discussions about there is money out there to be had, including if you wanted to incentivize asset recovery. So I think that's definitely something to think about. There may be a public-private partnership that was more kind of commercially incentivized. But that's my hope for another idea apart from getting the government to legislate.
Are there any questions? We've got a roving mic for those in the room. Sarah Longdon, our wonderful marketing manager, is holding. We're very happy to have a go at answering some of your questions.
Or just adjourn and get a drink.
Or we may have covered absolutely everything, in which case, wine for this, for those of us who've made it into Quadrant.
We can answer questions over drinks if that's easier.
Yeah, well, look, let me thank the speakers on our behalf: Yash Kulkarni QC, Emily Saunderson, Nick Van Benschoten. You can join us for our next in our series of fraud talks on, well, tube strike permitting, on the 23rd of June, that's a Thursday. The subject of that talk is the curious case of the banker and the app fraud, when I'll be joined by barristers Simon Oakes and Nicola Alsop, and Katie Warbeck, the UK Finance Managing Director of Economic Crime, one of your colleagues, Nick.
My boss.
Your boss. So from all of us here at Quadrant, to all of you joining us virtually, thank you very much for coming. And for all of you here now, we look forward to meeting you outside with a glass of something appropriate. Goodbye.